So we'll look at foreign community property. And with the situation between Henry and Lynn, what is the community property rights? So what is the basis of community property rights in the US? What's the application to inherited and premarital property? And whether pre and post-nuptial agreements are legally valid. So John, can you please address these questions?
I can, and I can be succinct. Unfortunately, it's not the kind of succinctness that I think that people will like, which is, this is every lawyer's favorite answer. It depends. Each state has its own definition of marital property, and that definition, they can vary widely in the US. A state like California that is perceived as being more progressive might have a more equitable community property approach to sharing of property, both that's brought into the marriage and that's acquired during the marriage, whereas a state that comes from a more conservative perspective, say like a Texas or a Florida, might have a much different definition. So the answer to this question is really going to depend upon what state has jurisdiction over that relationship. And that can vary also with the definitions applied. If they've lived there for a short period, as short as say like 8 weeks, some jurisdictions might adopt that as their residency rules taking effect. Others might have a longer period of time before you trigger the marriage being in that location and their community property and definition of marital property to apply. Like I mentioned, inherited and pre-marriage property, it can be covered in some progressive states like California, and potentially not covered in other states. And then from a pre and post-nuptial agreement perspective, they are valid in the US. We tend to want to see 4 rules of thumb followed with them though. So each party should have their own counsel, not using the same counsel to look at the document. We want to see full declaration of assets, openness. If one party is shielding off some asset that they're bringing into the marriage, that can be a strong factor in invalidating the agreement, either a pre or a post-nuptial agreement. The agreement should not concern custody issues or duties during the marriage. So it shouldn't say this kid will go with this person, or this person has duties to raise children or do certain household responsibilities. Those are not proper things to discuss or have be valid in a pre or post-nuptial agreement. And then lastly, and this is just for prenuptial agreements, obviously, we want to see it a good 5 to 6 weeks ahead of the marriage. So not something done in haste a couple days before or the day of the wedding. I think there'd be a presumption that that was under duress or not properly executed.
Thank you, John. So moving on, the next question is, would a foreign community property ownership be recognized in China? And this question, perhaps Frank.
Yeah, so first of all, it really depends on the application of which law. So if the PRC law applies, even if those the couples are non-PRC nationals, for instance, the couple lives in China, their domicile is in China, then the likelihood of applying PRC law is pretty high. And then likely the PRC court will apply the PRC community property rule for the couple. However, even if let's say we have a case in Shanghai a few years back, it's a Hong Kong couple with Hong Kong passports. So they have assets to have dispute after divorce located in Shanghai. So the Shanghai court decided to apply the Hong Kong law in adjudicating that dispute for the reason that the couple, they are both domiciled in Hong Kong with Hong Kong passports. So it really depends on the couple's domicile, and if the domicile are not in China, then they will apply the law of that jurisdiction for the domicile.
So Frank, applying that principle in this situation, because Henry and Lynn live in the US and domiciled in the US, so in respect of the Chinese property, the real estate and the company, presumably the court would follow the same principle and look at the US matrimonial law and divorce law.
Yeah, which happen to be very similar to China as well, because they also have the same community property rule. Is that right, John?
It can be. Again, it comes back to which state is applying it.
Mm-hmm.
Right. Okay. Thanks, gentlemen. We'll move on to the next question. Would foreign community property ownership be recognised and enforceable against the Singapore Trust? And would foreign community ownership be recognised and enforceable against the Cayman Company shares? So Zach.
Yeah, I can do this fairly quickly. As we mentioned before, Singapore wouldn't apply a lot like Hong Kong, doesn't provide any firewall protection against the matrimonial regime that applies. So what would happen is there would be a claim by effectively, let's say Lynn in this case, that assets put into the trust were community assets under US law and therefore were not fully disposed of by Henry. And Singapore law doesn't provide protections against that. It would be effectively a claim made in Singapore on a proprietary basis. And in fact, no jurisdiction has tried to block that type of claim because effectively the ownership, the matrimonial domicile has decided that that was jointly held assets, and that Singapore applying common law principles would follow. And the same thing in the Cayman Islands, applying common law principles again, they would look to the matrimonial domicile, they'd look at the sort of effective community rights there, and then they would transpose it to the foreign held asset, in this case, movable assets in the shape of the Cayman Island shares. So again, Cayman would be expected to follow that.
Thanks, Zach.